Hi, and welcome back to Celebrity Corner. Today, we're looking at a custody dispute involving Texas-born singer and talk show host, Kelly Clarkson. So after her high-profile divorce from Brandon Blackstock, custody became more than just a formality. It turned into an ongoing struggle across state lines. So today we're asking, would Kelly Clarkson's custody order change if this case had happened here in Texas? So after Kelly filed for divorce, she was awarded primary custody of the couple's 2 children and remained in Los Angeles while Brandon stayed at the couple's Montana ranch. The distance created immediate tension. Brandon challenged the visitation schedule and tried to push back against Kelly's sole decision-making. Meanwhile, Kelly was juggling a demanding showbiz career while also maintaining stability for the kids. This situation mirrors what many Texas parents face when one parent moves and the other wants to change the original agreement. In Texas, either parent can file a modification case when there has been a material and substantial change in circumstances. A change in residence, a new job, conflict over visitation, or lifestyle differences, any of those could qualify. If Kelly lived in Texas, her move to LA and Brandon's preference to remain in Montana would almost certainly prompt a review by the court, especially if the visitation schedule became unworkable. Texas courts prioritize stability and continuity for the child. So if the move creates too much disruption, or if the long distance setup isn't serving the child's best interest, the court might modify the visitation plan. This could involve extended holidays, reduced travel requirements, or a restructured custody arrangement altogether. But it wouldn't automatically favor either parent. Judges weigh consistency, parental involvement, school performance, and emotional impact on the child. Also important, under Texas law, if a custodial parent moves far enough away that regular visitation becomes difficult or impractical, the other parent can request expanded possession or even seek a change in primary custody. It's not just about where the parent wants to live. It's about how those decisions affect the child's relationships and routines. A parent can't just move away and expect the original schedule to hold up if it's no longer realistic. Kelly's case also sheds light on another critical Texas standard: the willingness of parents to encourage the child's relationship with the other parent. If either parent is interfering with visits or communication, that's a red flag in court. Kelly and Brandon's case reportedly involved communication breakdowns, which would factor heavily into a Texas judge's ruling if either side sought modification. So if you're dealing with a long-distance co-parenting situation, or if your custody agreement no longer fits your family's reality, Texas law gives you options. At the law office of Bryan Fagan, we can guide you through your modification case and help you create a parenting plan that puts your child first. Click the link in the description or call us today to schedule a free 30-minute confidential consultation. We're here to help you find the best path forward.
Thanks so much for watching our video. We hope you found it helpful and enjoyable. If you liked what you saw, please give us a thumbs up. Got any questions or thoughts? Drop a comment below. And if you know someone who could benefit from this video, don't hesitate to share it with them. For more awesome resources, check out the description below. Take care. We'll see you in the next video.